Return to court list. Item number 1, pronouncement of order. Any mention?
Yes. Please, Lordship. I beg to mention item number 9, 10, and 11, Lordship. These are connected matters. I'm praying that this matter may be taken up after 2 weeks, Lordship. Why? Lordship, and similar matter is pending before Court 3, Lordship, and that matter is listed today for hearing, Lordship.
Around
This is an application and
washing of affair.
Lordship.
Yes, for the state. No one is appealing for the state here.
Lord, I'm for the statement.
Which one? Which item? All the items.
9, 10, 11.
Any objection?
No objection.
Just at the request made on behalf of the petitioner. This matter after 2 weeks.
Deeply obliged.
Wait, please, Your Lordship. Lordship, I beg to make a mention of item number 7, Your Lordship. Your Lordship, I pray if this matter may be taken up after 2 weeks, Your Lordship, as the learned DSGI is indisposed, Your Lordship.
Yeah, for the
I'm appearing on behalf of Mr. Chanda.
No objection.
They have informed Mr. Chanda. No objection.
He's
No
was
objection.
informed that it's not well.
Lordship.
It will be after 2 weeks for the request made on behalf of Ronex DSGI. Made by such and such. Give her name. On behalf of
Similar prayer for item number 12 as well, Your Lordship.
12. Who is there in 12?
I'm for
You
the
are
other
there in
side.
12.
No objection.
You have objection.
No objection.
Your Lordship, there is an interim in this matter, Your Lordship. I pray if the interim may be extended, Your Lordship.
What is the interim order?
So the proceeding of the trial court has been stayed
Till
till the next returnable date, that is today.
is it?
So
That is it correct? Mr. Agarwal is appearing here.
yes, sir. I'm assisting the senior advocate. Your Lordship.
You are not audible, Mr. Agarwal. Check with your.
Proceeding was stayed on the last occasion.
It's all right. There, see, probably Mr. Majika is not in good health.
No. I'm not objecting to it.
We will just adjourn it, and then interim order will be extended.
Yes, madam. That will be extended, madam. And while fixing any date or it will come after 2 weeks.
It will come after 2 weeks. Just verify the thing.
Okay, my bad.
Whether we have friend method. Until further.
That will be better. That will be better. Otherwise, extending it.
That will be all right. Yes. Yes. The interim order passed earlier will continue. Interim order has been passed in this matter or
In the miss case, Your Lordship, in
in
this
the
matter.
miss case? Oh, then in the miss case you just say. You see, miss case also you just say on the request made on behalf of the. I think you are the applicant in the miss case.
Yes, Your Lordship.
You list this matter after 2 weeks. Up interim order passed earlier shall continue until further.
Much Lordship, I beg to mention item number 8. My
Yes.
Lordship, I begged to take up this matter after 2 weeks
You're making a mention on behalf of?
on behalf of the petitioner
Why? Why do you want adjournment?
because of the personal difficulties, my Lordship.
Whose personal difficulty?
My lord, as they is the counsel for the.
There are so many councils. Not only not only one council. Yes. When do you want?
After 2 weeks, my Lordship.
Yes.
Obliged, sir.
My Lordship.
Supplementary process. Item number 2.
Yes. You see this matter, all the respondents has appeared. This matter is connected to item number 4 in main list.
Okay. This came up yesterday, isn't it?
Yes. Okay. Worship, this is challenging the order passed by the STF committee and in WPC 164.
This one, I think all the parties, all the respondents have appeared.
Yes, Lordship.
So you have you filed your responses?
We'll file, my lord.
Let them file your response.
My lord.
Administrator. Kareem, you're representing which respondent?
My lord. Number 5, my lord, in this case.
Mr. Jarwa is appearing with you.
Yes, ma'am.
Two, three, four. I'm here, Your Lordship.
Okay. It is submitted by all the respondents who have entered appearance. All of you will be filing a response.
2, 3, 4. We are not filing here.
2, 3, 4 also will not file. Okay.
Will not file. Will rely on the records.
Okay. For the response, the learned also appearing for the one. Learned he is senior G appearing for the number 1. And Mr. Inta Learned number 4 submit. Get. What about you?
I'll be filing.
And what about 6 and 7? You will be filing. However, counsel for the appearing for the number 5. However, Mr. L. Kareem, Learned counsel appearing for the 5. And Mr. Nagri, Learned counsel appearing for the respondent 6 and 7. Pray for grant of some time to enable the said respondents to file their counter affidavit. Prayer allowed? How long will it take? 2 weeks, Pala? Prayer allowed? This doctor? 2 weeks. 2 weeks, Pala. 2 weeks. Oh, this okay. Yes.
But item number 4 also is connected to this matter only.
Lordship, there's
In the main list, my lord. This matter has arisen out of the order which has been passed in this in the present petition. This was a similar order will allow.
so, Your Lordship, there's urgency staying the because you have filed this petition and
Okay,
they
there is a stay application.
yes,
There is
yes,
an application for stay. Then
Yes,
okay,
Lordship.
we'll let it be called.
Daily costless. Item number 1.
Is criminal revision petition.
Item number 2.
May please, Your Lordship.
Yes.
This matter will need some more time, Your Lordship. More time may kindly be accommodated. 2 weeks.
What is the matter about, madam?
That grant of parole, Your Lordship.
Okay, the parole matter.
Lordship.
You do not have an instruction.
Lordship, instruction is not
Just
complete.
matter pending before apex court also.
Lordship, yes.
What is
That's
the
why
outcome?
I would like to have the complete instruction in the matter. 2 weeks time only, Your Lord.
And issue by non-age age. Appearing for the state respondent prays for grant of further 2 weeks. To enable the to file a counter affidavit. They are allowed. Please step it.
Apply, Your Lord.
Highly obliged.
Item number 3. Item number 4.
Yes.
This matter pertains to the Your Lordship. What happened is in the Asir Autonomous Council election of CM and William James Act 2007, said that there's a error. That's a printing error in the Gazette of the Act. Now, what happened, Your Lordship? The District Council, and the District Council has amended that one through a corrigenda, Your Lordship.
How do you say there is a printing error in the Gazette?
That's the private respondent has raised objection in the District Council. Based on that, they have come up with that.
Was there any difference with the bill, the proposed bill, and the matter which is printed in the Gazette?
No, Lordship. Now they have decided that as per the bill is correct non-cloud, but as per custom it should be non-clouding.
So
The bill is correct.
that is not a then clerical error.
No, Your Lordship.
This is a change of the legislation.
The legislation is not changed as per the finding, but it's only that
As per the finding of
the EC, there's a new the EC, Lordship. The order which is under challenge now, Your Lordship. So what happened? They said that non-cloud as per that schedule, there's no error, Your Lordship, in printing non-clouding. But now they have come up that said it's non-cloud. But as per custom, it should be the person holding the minty is non-clouding.
how this court will decide whether if it is not a dispute in clerical in nature, then what would be the basis? Is it not for the legislator itself?
That's what I said. If they have come up, they should not have come up with the agenda. They should have, if there's error, they should have amended in the house.
So you want to say the non-cloud and term non-cloud and term non-cloud
Two different.
will carry two different
Yes.
meaning.
As per the claim
This
also.
will relate to two different kind or two different.
Plan. As per the claim in the
Is it correct?
petition.
This will.
Not, as far as non-cloud is concerned, there'll be only one non-cloud clan, my lord. If it's Ringi, there'll be a certain womb, my lord. My lord is aware of it, like maybe 3 or 4 womb only. That is the distinction which they are trying to make. If it's non-cloud, then the entire non-cloud. If it's non-cloud Ringi, then it
Who is for the district council?
Lordship, originally in 2007, the same of William had given a proposed bill wherein the term non-clouding was reflected. Then when the matter came to before the active committee, we also accepted that it is non-clouding.
You just check your audio, Mr. Desai. Your volume sometimes goes down.
Yes, Your Lordship.
Yes, please carry on.
Yes, originally in 2007, the proposal was that the clan Nongkhlauringi from the Nongkhlauringi will become the entry. And this proposal was also accepted by the executive committee. And thereafter, the House also accepted that it is Nongkhlauringi. When the bill reached the district council affairs, at the time of the assent, then the word renew disappeared. Only Nongkhlaur is reflected. Thereafter,
That happened in 2007.
I'm talking of 2007, the original proposal.
Okay.
It was Nongkhlauringi. Thereafter, after the House has passed the bill, it was Nongkhlauringi. At the time of printing the bill, it became Nongkhlao. The word Ringi disappeared. Thereafter, there was a collision.
When this mistake was detected?
I think it was detected later. I mean, I cannot say right now.
Later means when?
I think my colleague will be able to say that.
Original proposal was of 2007, isn't it?
Yes, Your Lordship.
That mistake was detected when?
There was an earlier writ petition filed, and that matter was agitated by the respondent number 5. If I'm not mistaken.
After 10 years. The mistake was detected in 2017. The act continued that way.
So now, in due course, after the collegium was issued, then the executive committee, for some unknown reasons, sought withdrawal of that collegium. Then the writ petition was filed before the then Chief Justice. A decision was made that the matter be sent back to the district council authorities, and thereafter, after hearing all parties, the order was passed that the term Nongkhlauringi will remain. And however, when it comes to eligibility, it will be from the womb of the Nongkhlauringi. So that is always the case, Your Honor. Now they have filed a writ petition. That writ petition was heard at item number 2, supplementary. That is the main writ petition, Your Lordship. Now,
the one thing this court has not understood, say, supposing if there was a error which was clerical in nature.
Yes, Your Lordship.
Why it was needed that the party should be heard before the correction is made? Now, what is the legislative intent? You see, the district council knows it very well, isn't it? They are not supposed to determine after hearing the parties.
That was as per the direction of the then Honorable Chief Justice, that it was a consenting order.
Where is
that the matter be.
Is it page annex 9, 180?
180.
This is the order?
Yes, ma'am.
It was passed by the Chief Justice.
The Chief Justice.
Okay, there is no dispute that the act was published in some variance with the proposed bill. So that part is disputed.
No.
So if it is not disputed, then what is there in the proposed bill that will be entered in the act? That would end the matter. If it is to be contended that this is a clerical mistake, so that is how it is to be corrected. So what more is needed here?
In spite of that, they were heard. Parties were heard. Order has been passed. But that's what withdrawn subsequently.
Now, the executive committee at that relevant point of time in 2018, by an executive decision, they withdrew that original bill.
Due to procedural lapse also.
That is why we filed a petition before. The publication will be of the bill which was passed by the House, isn't it? It cannot be anything else. So if this bill was not disputed, yes, and the publication was something which was not in accordance with that, there was a variance. That will be only corrected to the extent which you see, like if the variance is
Because
found.
even, Your Lordship, when the bill was about to be passed, 1 month's notice was issued to all parties concerned who are interested if they have any objections to
Okay.
the bill before being passed.
Then what was the order passed by this court at that point of time? What is the direction here?
That is at page 185.
180.
Para
Paragraph 16, Malad. Starts.
Acha. After the detection, it was corrected. Then
Malad.
that correction was again withdrawn.
Withdrawn. Malad.
Withdrawn by an executive decision.
Origin.
Correct also
No,
by
but then very withdrawal by whoever it is. If it is not in accordance with the bill, then that withdrawal also will be wrong. Then
correction also.
if we go by the fact that if we go by with the fact that the variance with the bill is not disputed,
Bill was never disputed
then
when it was passed.
that is the extent this court has limited scope to interfere. Cannot go and find out what is the reason, purpose, intent behind the legislation. We cannot say that.
Your Lordship, in 2016, the EC has also decided that the act is correct. Now, the same person who passed that order on 3/11/2016, the same EM, which passed the order which under challenge that it is wrong. First, they have said that the non-cloud is correct, the EC. By order dated 3/11/2016.
But anyway, this court, just a second, just a minute, just let us just understand. The matter was remanded to the HETC.
KJDC, Malad. On the basis of the order of the
that has to be non-cloud or only non-cloud. Now, once that bill is not disputed, then why a decision was needed to be taken that what should be the entry?
just because of the order passed by
Is
this
it not
honorable
a
court,
perusal of
Section
bill
9.
will clarify the entire thing?
Bill was never disputed at any point.
No,
So
Your Lordship,
what the bill carried?
one bill
And
carried
if that is the
non-cloud.
part, has to be the legislation.
One bill carried non-cloud, one bill carried non-cloud, which they have produced, which I produced a non-cloud.
But then the court says that there is no dispute with regard to the
No,
bill.
Your Lordship, that point only the district council has been clarified before the earlier round of litigation. That the bill, when it was passed, it was non-clouding. That position has been clarified.
And now also that has been retained.
Malad.
Then what remains then?
Now, Your Lordship,
By
they
virtue
say,
of the impugn order, Malad.
they say non-clouding is before they say non-clouding and non-cloud separate clan. Now they say that it should be non-cloud. Now it's a womb, but as per the definition of the act of Mentri, it should be from the clan, Your Lordship, not from the womb.
non-cloud is a common surname.
But the only person who are eligible are these non-clouding who belongs from this four homes.
But the act says that it should be from the clan, Your Lordship. Now they say that they said that separate clan, non-cloud and non-clouding. Now they also finding that as per the act it's non-cloud, but the womb non-clouding. But the definition of Mentri should be from the clan, non-cloud, Your Lordship.
Non-cloud, Malad, only 4 wombs from one particular clan, only 4 wombs from that particular, if non-cloud ringi is taken into consideration, only from the 4 wombs will be eligible to contest for the post of Mentri,
Along
Malad.
with non-cloud.
No, my lord.
Only four wombs from non-cloud.
Only the 4 wombs, my lord.
But the act definition
That
is
is
Mentri is clan, Your Lordship, clan.
And that decision has been taken as per the customary practice, which has been reflected in the.
I do not know. This appears to be some unnecessary dispute arisen because of the way you all move. A matter which could have been simply resolved has become very complicated.
My lord. My lord, what are
This order of
what are
this order of the Honorable then Chief Justice, Your Lordship, order dated 27/9/2023 was put to challenge in writ appeal. And in writ appeal, Your Lordship, just recently, by order dated 14/5/2024, that is Annexure 16, at page 202, the matter has been.
This court was a part of that.
Yes, Your Lordship.
Yes, Your Lordship.
And what happened there?
There, Your Lordship, at page 205, especially para
That's
4.
item number 2 on the supplementary list, my lord, where your lordship has was pleased to grant 3 weeks time to file the affidavit, my lord. This I
Actually,
true,
both
my lord.
matters are interconnected.
That is all right. And then you are a Mintri.
Yes, Your Lordship. Now some but
Now, when did you become a Mintri?
since 2000,
After the correction.
just 3rd August
After
2018.
after the way back after the 2007 was the act passed, my lord. After that only, my lord.
When the new word was missing, then they took advantage of that.
After the EC has decided.
They realized in 2017 that in the act, the word renewed had disappeared.
No, Your Lordship. After the SF committee had decided, Your Lordship,
No, this code
in
is
page
not-
114, Your Lordship, I'd like to take it.
Just a minute. Originally, 2000, the bill said it is non-cloud only. Okay. 2007 Act came.
My lord.
It mentioned non-cloud.
Non-cloud, Lordship. Non-cloud, Lordship.
When it was assented, the word non-cloud was reflected.
Bill was non-cloud.
At that time of publishing, the word renewed was missing.
2007. It was only non-cloud, it means.
Non-cloud.
When the act was passed, my lord.
Then the mistake was detected and corrigendum was issued in
2017.
17.
Then again it became non-cloud.
Yes.
My lord.
And they withdraw due to procedural lapse, Lordship. And there's a letter from DCA, Lordship, District Council Affairs, to come by way of
Then they
amendment.
withdraw that.
Yes,
Withdraw
Lordship.
this
My lord.
corrigendum.
Yes, Lordship. 2018.
The corrigendum was withdrawn on the basis of a executive committee decision. That was
challenged.
to the District Council Affairs, then that is why they withdrew.
That was challenged by them, my lord.
Then we came before this court.
No, Your Lordship.
So after the withdrawn, it was challenged, isn't it?
My lord.
Challenged in 2023, Your Lordship, after 3 years, 18, 19,
Okay.
23. After 5 years, Your Lordship. The challenge in the year 2023 after 5 years.
Then Annexure 9 was passed.
Annexure 9 is the order of the High Court.
My lord.
And then
27/9/2023.
Annexure 9 was.
and then this impugn order was passed. The impugn order which impugned here.
My lord.
Isn't it?
Yes, Your Lordship.
No, my lord. Prior to that,
During the pendency of the writ appeal, Your Lordship.
The former Chief Justice order in Lordship was carried here. During that intervening period,
That is what. So impugn order is under challenge here.
my lord.
Now, what this
impugn order before this particular matter, Your Lordship, is only with regard of the suspension of the.
now what this impugn order says? Let us come to the impugn order.
Page 200.
My lord, the last paragraph. My lord. 201. My lord.
Corrigendum.
It's 201.
What is this page 191? What is this order?
Page, my lord.
Page 190.
And this is for, my lord has passed this order for adequate hearing.
So they came up with a plea that they were not heard.
Yes, Your Lordship.
Documents were not supplied. to
Okay.
them. So
The notice was issued to them by the
They
District
took
Council.
part in the hearing.
My lord.
two parts. They argued also in the.
What is the impugn order? What is the impugn order? Is that
200,
page?
page 200, my lord. Last paragraph.
Just
201.
yes.
The Executive Committee, having considered from all angles perusal of written arguments filed by all parties concerned and taking into consideration the narrative above that the supremacy and authority of the House in its session is always respected. Nevertheless, there is no doubt that the Mantri of Himamalayam is from the Nongklao clan and also known as Mantri Nongklao. But as per the records and customary practice in Himamalayam, the said Mantri Nongklao is only from the Nongklao, Rangi, which comprise of the womb, four wombs, for namely, so and so, so and so, and so, to be known as Mantri Nongklau Ringi. However, it is not necessary that the term Ringi is to be incorporated after Nongklau in the Schedule 2 of the same bill.
Now they have contradict themselves, Your Lordship. Now because before they came that it's a separate clan. Now they say it's a womb.
The womb would not mean the entire clan.
No, Your Lordship.
No,
There,
only four wombs.
But the definition of Mantri is from the clan, Your Lordship.
now here with this finding recorded by the executive committee, is it in contradiction with the original bill?
No, Lord. Nongklau means like the bill is correct, Lordship. Only Nongklau.
Bill is correct.
Here they finding that the Mantri Nongklau, that the word Nongklau is correct. It should be only Nongklau. If it's only Nongklau, then they have come challenge that there's a wrong printing error, everything.
Yes, agreement. See, then it was corriendum was used. Then it was withdrawn. It came into Nongklau.
Oh.
It remained as Nongklau.
Yes.
So it means this order does not change the legislation, isn't it?
Yes.
Then it remains. Then what is the problem?
It remains Nongklau. That's why they have removed. But why they remove you from the post of Mantri? That's why.
So this order doesn't disqualify you. It does not have the effect of disqualifying absolutely.
No. Then if only the four womb are eligible for Mantri to become Mantri.
Now they don't disqualify because they said it's Nongklau. The definition of Mantri is from the clan, Nongklau clan. Now here the findings.
What is that? Original act? Does it remains due to not one legislative thing? Why we needed interpretation by the executive committee?
Your Lordship, can I make a prayer?
Yes.
If this matter can come again tomorrow, I'll physically be present in court, Your Lordship.
Yes, that will be better.
Yes, Your Lordship.
I think
Tomorrow or Friday. Mr. Paul also will be back on Friday.
Pick up on Friday, Your Lordship. I'll prepare the gist also. Gist and the list of.
Yeah, it is better. It just you clarify that part, that thing. It remains confusing. As per the original bill, what was the original bill? Then what was the publication? Then what is the corrigendum? Then what is the withdrawal of corrigendum?
Yes.
And then come to the impugnment.
Yes, I'll write that all in detail.
The order passed by this court, by which it was remanded, the single bench order, paragraph 17 says that it is supposed to be direct to take a decision in as to whether reference of
Now also direction to legislative wing. What's the legislative wing, Your Lordship?
Yes. Okay. What is the relevant part of the act? Hardly, that is 2007 Act. This is Schedule 2, isn't it?
Yes, Your Lordship.
Well,
Schedule 2 is number 5, Your Lordship.
5.
Non-claw.
Serial number 5.
Name of the clan non-claw, isn't it?
Yes, Your Lordship.
So if it is clan, that will mean clan to clan non-claw. Then what more was needed here?
Now, Your Lordship, the definition for Mantri in.
See, the order of the single judge is confined only to the
Whether Nongklau or Nongklau Ringi.
issue that whether the Schedule 2 to the relevant act has to be non-claw ringi or non-claw.
Yes. Now
So it remains non-claw, it is also non-claw. Then why the further clarification in the impugned order?
that's what
That was not called for.
not called for. Based on that clarification, they have
If
removed.
it is a non-claw clan, it is non-claw clan. You cannot confine it more. That will remain as clan. Anyway, we will have it on Friday. You see, we will not make these things complicated. We do not want to make it complicated.
Okay, Lordship.
If it is a thing, though probably we do not know that like how far this executive committee was correct in interpreting that. If it is clan, then it is clan. Whom doesn't mean clan.
Yes, Your Worship. It's against the definition of 2N also, Your Worship. Mean 3 should be from the clan.
You do not come under those 4 whom, isn't it? So that is why now they say that you are disqualified.
Yes, madam. That's why the impugn order has
But
been
the act
passed.
say long cloud,
That
whole clan.
appears is apparently appears not correct. Who are you? Hmm? You are not much relevant to us. You are not, so far as the issue is concerned. Only district council will clarify. Okay, that's the thing. And then
We will act upon the decision of the
that is
this
what, but
council.
then is apparently it seems that this order is not correct. Only just say on the joint request made by the parties,
Well,
this is matter on Friday.
Much obliged.
Hearing item number 5.
My lord, this is a matter land acquisition.
Yes.
Lordship direct the respondent to produce the record relating to award, passing of the award.
You have received awards.
Yes.
What is the case here, Mr. Sangresho?
Well, here the land was acquired and the Section 9 notice was issued to the petitioner.
After compliance of Section 4.6, under the old Act.
Yes, under the old Act. So
4.6 and then came Section 9.
Section 4.6, name of the petitioner not mentioned, even their name, their land also.
Was not mentioned.
Not mentioned. In subsequently Section 9, the notice was issued to me mentioning the detail of my name and the houses, the trees, and the hearing did not take place. And subsequently, they never called for a hearing and proceeded the acquisition and taken over my land and utilized it. And this is the case.
And what is the state's contention?
State's contention, they did not deny Section 9 notice.
But they deny your ownership. Over the
They say that, no, we did not acquire your land. There is no land as such. And they did not clarify then that whose land you mentioned under Section 9. If it is not my land, maybe perhaps it belongs to somebody else. If that is the case, maybe I may file a suit.
You are placing your case. Do not place your case now. Just asking what is the court, the state's contention.
State did not deny. State did not deny the existence of Section 9. Till today, they are not revoking.
Say, the case here is that you said that since Section 9 notification was issued to you,
yes,
that means your land was acquired.
Yes.
But then they proceeded to, you see, like go ahead with the litigation without paying you any
without paying me any compensation.
Okay. And then now that is why you are before this court.
Yeah, before this court.
Now, their contention is that you do not own any piece of land, isn't it?
My lord, they did not.
What they say about Section 9? What is their reaction about Section 9?
Section 9, they said, yes, we issue Section 9. But mere issuance of Section 9 do not confer right upon you. That is what they say.
Is it not correct? Or you say that the issuance of Section 9 would prove your ownership?
My lord, if they wrongly issue Section 9, they could have revoked it. That would be acceptable.
And if it is
wrongly,
not,
we prepare.
Just a minute. What would be the interpretation? They have not revoked it.
They did not.
That order stands.
That order stands.
So it means the issuance of Section 9 would make you make you owner.
My lord, is a recognition of my prima facie ownership of the plot and the building, the trees.
What Section 9 says? What is the language used in Section 9?
My lord.
You will add it. What for you ordered the production of the award statement?
My lord, in the last occasion that discussion reached and lordship desired to know the date of award.
Let me just clarify. What happened was a very lengthy hearing which took place on this issue. So court was also of the opinion and the state also is of the same opinion that in initial stage their name was not there in the Section 4 notification.
Not there. Section 6 also not there.
For some reason nothing specific was mentioned but Section 9 notification was given. For some reason. We're not denying it. And then after Section 9 lodged, then the award was made. And in the award, his name was not there. And he says because Section 9 name was mentioned, so he has got a right. Now, when the award was made, his name was not there. And then the state only contention was that, Your Lordship, even after the award was made, or even before this present writ petition, he has not produced any document to show that how he is the owner. Lordship, we stop at that point. Then the court wanted to find out, Mr. Khan, please kindly produce the award. Whether in the award, this name is mentioned. So we have produced the detail, Your Lordship can go through it. His name is still not there in award event. And Lordship and the state is in the same page so far as such dispute arises, even for the sake of argument. Because he did not produce, even in writ petition, any documents to show he is the owner. Our condition, Your Lordship, as a state, I would have
Is it
felt.
not a case which will be covered by Section 30?
Absolutely, I'm coming to it, Lordship. Lordship has just taken away the word from my mouth. That is exactly what was the summation. He did not produce even any document except for a certificate showing he is the owner.
No, after the award,
If at all, Lordship, even in the award, his name is not there. But if he claims that he is still the owner of the land and he has got sufficient documents to show, then the remedy lies under Section 30.
but the Section 30 he has to file an application, isn't it?
Yes, Section 30.
The moment there is a dispute with regard to the ownership, Section 30 comes.
30 comes in. Lordship, the language of Section 30.
So probably we wanted to see the date of award.
Yes.
To ascertain whether
his name was there or not. We stop at that point.
So after the award, was there any objection filed by them?
No.
He did not object to it, Mr.
He did not object.
We are not aware of date of award. Section 9 is prior to award.
That is okay. But
Yes.
then once you say that you were given the notice under Section 9,
Yes.
was it not for you to keep an eye on the thing, what is
My lord,
happening?
we put up the application to hear me under Section 9. That was there. They did not dispose of. They did not reply also.
The state stand is, Lordship.
Can this court order inclusion of your name in the award?
My lord?
Can this court order inclusion of your name in the order?
My lord, therefore...
Without you establish your
yes
ownership,
my
how
lord,
this court will give will see that you will find out that you are owner of the claim.
my lord, with due respect, here this honorable court, before this court, I do not need to adduce any evidence to show my ownership. Now, admittedly, state has issued notice based on facts on the survey.
See,
we are not
Section 9
disputing
speaks
this.
notice to the interested person.
Interested person.
Interested person doesn't always mean that you own the right.
My lord, I mean, your lordship is correct. Interested person, they issue notice to interested person. It is the duty of the collector to hear me. That was not done. That is the grievance of the petitioner. If they hear me, collector hear me and say, oh, you're not interested person at all.
What happens if it is found out that this issuance of that notice was by mistake? It was not called for.
They could pass a definite speaking order. That we will know the reason of the issuance of wrong Section 9.
That is their stand that you were not required in fact.
Yes.
So a mere issuance of the notice under Section 9 to you,
right,
would not prove your ownership. That is their stand.
Yes, and Section 9 is not the stage for proving ownership. Section 9 is not for the interested person, including the owner, to come and prove. They need to come and establish that the interested person.
For the purpose of, you see, showing your interest, section of interest, basing which Section 11 the award is passed.
Interest only.
Okay. Yes. So you go, if you are at all, if you have any interest in the acquisition proceeding, meaning thereby that if you have claim for compensation, then you respond to Section 9 and your response is considered, and thereafter they come to the stage of Section 11 by which award is prepared.
Exactly. So,
by taking into consideration.
Right. So
now, you say Section 9 was issued to you.
Yes.
And then, of course, you say that you were not heard.
Yes. And it is not the case of the state.
Now, if without hearing you, if any award came, then option for you was to file an objection against the award, so that the matter could have been referred under section 30 for determination of your claim.
Now, Lordship, that is the language of the section 30. If there is a dispute of award,
Huh?
dispute on the award, Lordship, section 30. I just take a.
See, any dispute arises to the apportionment
Apportionment.
of the same
Yes.
and any part thereof.
Yes.
Meaning thereby, say supposing a particular amount is sanctioned for a stretch of land, and there are 100 persons there, then all those 100 persons should get their share. Okay. Now that is where we say apportionment. Now you say you are within that 100%, and it has not been paid to you, 19% have been paid. So that you should have made your claim there. What is the limitation for section 30, Mr. Khan?
My lord, limitation is not there.
Section
And
18
Supreme
has
Court,
some period.
Supreme Court decision is there. The judgment is with me. Supreme Court held that there is no time limit for invoking section 30, but it requires to invoke within reasonable time.
So then you approach the
It is
collector.
It is there.
You approach the collector, write to him. What is the award? Just give me the award.
Yeah, award.
Have you seen the award, Mr. Shangri?
I've given a copy to him. If he wants, he can go through
No,
it. He can
they are yet to give.
page 2.
Why you have given this original letter here?
We have Xerox. We have a Xerox copy.
That is a forwarding letter to you. Why court should retain it?
We have numbered it sequentially so that no page is misplaced before Xerox.
You see, we have a Xerox copy of the same letter again. Then why this original should be here? Anyway, what is the list of beneficiaries?
It starts from. You give it the list which starts.
It's a long list, isn't it?
One list.
It's a long list.
A very long list.
So, well, Lordship permission, if Lordship give me some time, I'll take instruction from the party also.
Please,
After
that is what you should do. You should go through it, because you will see there will be some names, isn't it? Names will be there, isn't it?
appears, yes.
So you just say who is it falls in your neighborhood and all. That may make things easier for you.
Yes, yes.
The fact remains, Lordship, he still have a remedy under section 30. It's not that he's rendered remedialess.
That is what is to determine.
For the first time they are producing this.
Only thing is that this is acquisition proceeding of which year?
2013.
2011, 12.
And when this award was made?
Award statement as per the date next is market value. Date mentioned is
No, where date is reflected. What is this?
Lordship will get the last column of
Even
page.
your order sheet also doesn't have date.
Yes.
Why it is like that? Your office should have checked it, Mr. Khan.
Apology, Lordship.
Person assisting should have checked those things. Those factors are relevant here. It appears, Mr. Shangri, there are 120%.
Yes. Any names are.
If they pay 120%, why they should not pay you? There's, I don't think there is any enmity with you.
Enmity with you, Lordship is correct. Only thing is he is not rendered
If
remedy.
you say that it is an omission, then also remedy could have been somewhere else.
Lordship, let him go through it. In case, as a Lordship
That-
rightly
That
said,
is what
Data about is not here.
he has said.
Let
He'll be
him
reading
produce
the
original.
instructions within section 6. Now, Mr. Sanglesh, tell us another thing.
Yeah.
When you found that your name is not there in section 4 and section 6 notification, did you file any
True,
complaint?
that is true of RTI. 2014.
No. You did not know about the issuance of notification under section 4 and 6 also.
Yes, they were not aware.
Then your name were not there at that time.
Yes.
The least happened to it.
Subsequently,
Now,
my lord,
when your name were not there, you did not file any representation.
my lord, they were not aware. They were not aware. After my lord,
So it means you want to say that section
because-
issuance of section 4 and section 6 notification also not in your knowledge.
Right.
And you suddenly wake up after getting section 9 notification.
Yes.
Perhaps you thought you got some lottery and all, and then why not try?
well, because section 9, section 4 and 6 are prior to section 9.
Hmm?
Section 4 and 6 are prior to section 9.
That is why.
So after this, my lord,
Just a minute. You said you fairly submitted here. Section 4 and section 6 is concerned.
your names are not.
Your name was not.
Yes, yes.
Now those notifications are not issued on the same day, isn't it? These were issued one after another.
Yes.
After you found that section 4 and 6 do not carry your name, did you take any steps?
We filed the writ petition after obtaining.
After
obtaining through RTI.
Before section 9.
Yes. No,
Okay,
no. After section 9, we received the section 9. They fixed the date for hearing. We went.
Wait, just a minute. After section 6, what you did?
Section 6, we are not aware. And because they invoked the urgency clause. Authority invoked the urgency clause, section 17. Now, section 9 they received. They went on that particular date fixed by the collector. Hearing did not take place. They came back.
So
they urged them to.
The fact remains that after the publication of section 4 and 6, no action was taken from your end.
Yes, since they are not aware.
You come to picture only after you received section 9.
Section 9. Hearing was denied. And thereafter, they obtained through RTI all the papers, including section 4, 5, section 5, 6, including other papers. Then they come to know that their names were, in fact, there in the.
And what is the nature of your claim here? It is your claim. Your claim is by virtue of your ownership over the land.
Yes.
Or you just claim is just because of the possessory.
No, on ownership. They're the owner. They are the owner.
So you are a
For-
recorded owner.
For of the money. They are the owner. No
And
birth certificate also.
your land falls within that stretch of land
Yes.
which was acquired.
Yes.
How this court will determine all those things?
My bad.
There is-
My lord, in those cases, my lord, therefore, the earlier occasion, I placed one decision. Lordship may even direct the district judge to conduct inquiry and submit a report to this honorable court.
See, conduct
There are
inquiry.
some judgments are there.
The inquiry can be conducted provided you show a strong prima facie.
Yes, yes.
We'll just not order any inquiry just because you comments.
Right. Exactly.
There has to be some supporting material.
Exactly.
Isn't it?
Exactly. My documents are there, and the government documents also show that my name is there. District council document shows that I am there.
Lordship, if you take your Lordship to just one important document, Annexure 810, page 129 of the writ petition.
Page 121.
129.
Anyway,
129.
see,
Let them
if you
produce
go to
the
merit,
award.
You'll be needing some instruction.
No.
So I think you see, Mr.
Let
Khan.
him
he has
take
something
instruction.
to-
Let him take
State
instruction.
of the award also
That is
not
better
here.
because the
Let
problem
him
is that
produce
this
original.
The only issue here, Lordship, that after section 9 notification also, what did he do? Only that part. Still, they never produced any documents.
See,
And they sought for time.
there are two things which comes to the mind of the court is that 4 and 6, if does not contain the name of a owner, he will be alarmed by the situation.
Correct.
There will be reaction from him. He will go and try to contact the authorities, see my name. Anyway, let us say this is not. Now, his only case is that he received a notice under section.
Yes.
Now, after section 9 also, he says, though he was present, but then you did not hear.
No, that's a wrong statement.
Okay.
That's a wrong statement.
Anyway, these are factual aspects. Whether wrong or right,
No,
cannot
page
say.
129 will answer it, Lordship.
Now, then the normal query comes that even if section 9 was not heard, was it not duty cast on him to immediately file one representation to the authority concerned,
Yes.
making his claim.
And with the supporting
So
documents,
that,
some
that
documents.
even in the
supporting
event of preparation of any award,
Yes,
this will be referred under section.
absolutely.
No, that is what.
That is
Because
not
you see, the remedy lies down in the act itself. Now, the law is very much clear. If any act holding certain arena provides for remedy, then that very remedy or the very provisions provided in the act has to be.
Yes.
Okay, the read petition will come only in case when authorities fail to comply with the laid down provision. That is.
So
Anyway,
let him take instruction also.
okay. Then just say pursuant to the
Well,
order.
I may pray. Let Lordship may direct the authority to produce the original because date of the award is not there. Date of the award is not here also.
Yes, the award is not there. Yes,
Lordship,
Mr.
How can we
will
ascertain?
confirm. Lordship will
Yes,
confirm.
That
Let
is
them
something not acceptable.
Yes.
Will
Order sheet itself, Lordship, is page 5. Very strange.
Even the order also doesn't have a date, isn't it, Mr. Shangaresh?
Yes.
That's why we give you the original copy. And you will cross check.
Let them,
You have
let,
the original records with
let
you?
them produce entire original
No,
records.
this was given to
You
us.
please obtain the original.
Yes.
We may not pass any order, but then please remember the original record. Original record you procure for yourself. We'll compare it with these things and try to find out the dates.
Yes. Okay.
Okay, as per the requirement of the order dated 28/5/2024. So the state respondent has a produce of the copy of the award statement. A copy of this statement has also been furnished to the petitioner. Come on, learned senior counsel appearing for the petitioner prays for grant of some time to obtain necessary instruction. Some time so that prays for some time so that the petitioner gets chance to go through the award
Yes.
and pass necessary instruction. Come on, the prayer made. The prayer is allowed. Stop. This matter after 2 weeks. You'll just obtain, procure by yourself. Please compare it by these things. Do not leave everything on the court.
No, absolutely.
But then there are certain duty cast upon you also that the court gets the correct picture of everything.
Absolutely.
And you should ensure it. You are the media.
Absolutely.
Okay. Please check 2 weeks. We have seen already.
2 weeks.
Shall we retain a copy of this?
Item number 6.
Very good.
Lordship, in this matter, we have just received our instructions, Lordship, and we need time to file the affidavit.
What for you needed this instruction, Mr. Thaba?
There was a
This was instruction with regard to
the reservation, my lord.
Reservation, yes.
There was a notification.
Okay, special level.
Disabled.
Special level. And there is a order passed by the Honorable Chief Justice to obtain instructions.
Yes, because there is a new notification by the state government saying that raising the quota to 4%, my lord. And if we take that 4%, my lord, I will come within the ambit of selection, my lord. That's why.
Okay. So, how much more time you will be needing here?
2 weeks will do, Lordship.
For obtaining placing the instruction? You are appearing for, madam? And what is your role here?
She is a selected candidate, madam.
Okay. There is no prayer against her. Or
No,
you want her ousted for
No. We are not.
You have a
seeking
very
her
fair.
My prayer is very limited and fair.
Live and let live.
Live and let.
Okay, Mr. Thabal on it. G appearing for the state respondents. Wait for grant of some more time to enable him to procure instruction in the matter. Mr. Thappa, Running Council of the petitioner has no objection. Prayer allowed, list of the 2 weeks.
Highly urged.
Item number 13,